So we're back with our second podcast with Åsa Gotthardsson from Swedish law firm Vinge. Today we're talking about the end of employment.
Hi, Åsa. So my first question for this second podcast is, what protections against dismissal do employees enjoy that employers need to be aware of?
Yes, so hi and thank you. Nice to be back. This is a topic that is perhaps most discussed and also most important when you would do business in Sweden and especially hire people in Sweden. Because when someone is employed on an indefinite term employment, the employer can only terminate the employment agreement by legal grounds, so legal objective grounds. And these are either redundancy or personal grounds. But the personal grounds area are quite limited or are a difficult area to be successful with as an employer. While redundancy has a formal process, but is in itself quite easy relatively to other countries. It is the employer's decision to make changes in the organization.
That sounds, I think, similar to what we have over here. So in the UK, employees with over 2 years service have protection against what we call unfair dismissal. And that means that there are limited circumstances in which a termination can be made, and the employer usually needs to go through a fair process as well as having a fair reason. If employers get that wrong, then compensation is capped for that claim at the lower of 1 year's salary or around £90,000. But because of that cap, we commonly see employees bringing claims for discrimination or very commonly now whistleblowing, which takes that compensation cap off. Do you have similar unfair dismissal laws in Sweden? And also, are you seeing the same issue at all with discrimination claims being made in Sweden?
So I would say that it is actually the opposite in Sweden. So even though damages are capped for unfair dismissal, but if you have been worked for 10 years or longer, the capped damages are 32 monthly salaries. So that's a lot. While discrimination claims have so far not been that expensive to employers, and we have a sort of in Sweden or under Swedish law, based on sort of our court system, perhaps we have a restriction or a restrictive vision on high damages. So typically damages would be seen as something you get for your losses or for the damage you've actually suffered. So you can't really be the sort of the infringement of being harassed or discriminated against isn't compensated that well. So it is in the preparatory work for the Discrimination Act. It actually says that it should cost employers to discriminate, but really in real life and in court cases, it doesn't really cost employers to discriminate. So this will become an interesting topic for the future, because I'm not sure everyone have heard about that, but in Sweden, it has so far has been possible for an employer to confirm a claim of discrimination by confirming the amount of that is claimed. So, for example, 25 Swedish kronor, so perhaps like £200 or something, or sorry, £2,000. And then sort of be good, contrary to what the EU directive has had as an intention, that the employer should actually, or the employee should actually been be compensated for discrimination. So what the discrimination ombudsman has been claiming and also has been successful in the European court is that there might be necessity for the employer to actually confirm that someone was discriminated, not only paying the low damages that are applicable in Sweden now. So this was a very long description, but to explain that it's quite different.
Okay, so it sounds like because your cap is so high, so 32 months pay is a significant amount of money. Because of that, you're not necessarily seeing discrimination claims come through because there's not really any financial compensation that attaches to that. But as I understood that, the way of dealing with that is to have the employers accepting or confirming that they have discriminated against somebody, which I suppose has a knock-on PR impact for them, as they're
exactly
then discriminating employer. That's an interesting way of dealing with it.
Yeah.
Perfect. So the next question is, so in the UK, separate to the unfair dismissal legislation, employers can terminate for cause. So they can dismiss immediately if for an employee is guilty of kind of gross misconduct. Do you have similar provisions in Sweden?
Yes. So with notice, it is required to have legal grounds or legal objective grounds as redundancy or personal reasons, and then it is also possible for the employer to terminate without notice if there is a gross misconduct. Yeah.
Great. Is there a process that you need to follow to get to that point, sort of to prove the misconduct?
Yeah, I mean, we don't have a statutory process before the actual notification. So there is sort of an obligation to inform the employee that we intend to terminate your employment with or without notice. So with notice, there's a 2 weeks period, and without notice, it's a 1 week period during which the intention is that the employee and or its trade union is entitled to have sort of a discussion or consultation regarding the reasons to terminate. And this is only if there's a personal reasons termination or a immediate termination. And so before that, there's no statutory process, but case law says that when an employer will or wants to terminate an employment due to personal reasons with notice, the employee must or the termination cannot be a surprise to the employee, basically. So there must be a reprimand letter or a warning letter, whatever you choose to call it, but in which it is made very clear to the employee that this isn't acceptable, and we expect you to do these and this and these improvements, and if you don't, we might end up in a termination of your employment. So having given that, and then depending on the position and the reasons for the warning, then there will be a certain period thereafter before the employer could notify the employee of a termination.
Okay, thank you. So here in the UK, we've got the unfair dismissal sort of legislative process. And then on top of that, an employer needs to comply with the contract of employment in terminating employment. So that usually requires notice to be given, but the contract might give the employer the right to place the employee on garden leave or to terminate with immediate effect and pay in lieu of notice. Do you have the same or similar concepts in Sweden?
I mean, yes and no. So payment in lieu of notice is not possible without this explicit agreement with the employee. So I would say that in 99.9% of a termination case, the employment will carry on or will continue during the notice period. And as a main rule or as a starting point, it is possible for the employer to put the employee on garden leave, but the garden leave isn't sort of a statutory concept. So there could be a lot of regulations or a complete section in an agreement from UK regarding garden leave, while in a Swedish employment agreement, we might say just that the employer it's possible for the employer to release the employee from working during the notice period, basically, because that is what it means. So putting someone on garden leave will not be attached to further regulation. So anything the employer wants to be applicable during that garden leave period must be specified either in the contract or agreed with the employee at the time of termination, basically.
That makes sense. And actually, that's broadly similar here. So we need to have the contractual right to put them, well, in most cases, we need to have a contractual right to put the employee on garden leave. And often our contracts will have fairly detailed provisions on what the employee can and can't do during those periods.
Yeah.
And next, are there any groups of employees who have special protection against dismissal?
Yes, there's one special protection group, and that's trade union representatives in a company with collective bargaining agreement. And we'll come back to that perhaps later on in our discussion, but not all companies have collective bargaining agreements, and not all companies with a collective bargaining agreements have local trade union representatives. But if there are, and there is a redundancy termination process, any trade union rep in the company will be exempted or prioritized, if you like, in a redundancy or from termination. Otherwise, there's no protection, but it might be valuable to mention that employees on parental leave, they can still be or should be, if they are subject to termination due to redundancy, they should still be given notice at the same time as anyone else, but the notice period will not start running until the employee is planned to be back from the parental leave.
That's interesting, and that's definitely different to what we have in the UK.
Yeah.
I suppose staying with that collective bargaining works councils, do employers need to involve works councils or other employee representative bodies when they're considering dismissing an employee then?
Yes. However, in Sweden, we would only talk about trade unions. So there's not really the concept of work councils or representative bodies in that sense. I know there is in other European countries, but so trade unions are, as a starting point, sort of an external organization outside the company, whereby employees or in which employees can be members. And that membership give the employees a legal counsel, basically, to either discuss with or to be represented by in connection with the redundancy or in connection with a termination due to personal reasons. And the employer's obligation in relation to trade unions are, to summarize, you could say that it is to consult with the trade unions before taking a decision on redundancies or reorganizations, or upon notifying the employee of the intention to terminate with or without notice. It's also an obligation to inform the trade union of that intention as well, in order for the trade union to reach out to its member and assist the individual in the discussions with the employer, basically. But no agreements needs to be reached in terms of those processes.
So it's a notification process then, yeah.
Yeah.
Perfect. The final question in this section. So what practical steps should employers be thinking about when they're trying to resolve a termination dispute in Sweden? So, for example, can you offer a severance package in return for the employee waiving their claims under a settlement agreement?
Yeah, so I think I at least need to touch upon the very common discussion we have with employers. It's kind of technical, and I'll try to explain it as easy as I can, but do let me know if you don't understand. But so this, if an employer terminates an employee due to personal reasons, the employee can claim that termination is invalid. And during any dispute, the employee will remain in employment. So for the 1 or 2 years that a dispute may carry on, the employee is employed, is actually also entitled to remain at work if the employee doesn't want to be on garden leave during that period. So, if the employer is successful in the end of that dispute, the employee is not forced to pay any salary back during that dispute period. If the employee is successful, then I mentioned the 32 monthly salaries, but that is the maximum damages. It could be from 6 months up to 32 months, depending on the length of service at the time of the court's decision. So if you would summarize all this, it could be like 2 years of a dispute and then 32 monthly salaries in damages. And that's too much if you ask any employer. I mean, that the risk of paying that amount to an employee is, of course, a reason for the very usual practice to enter into a termination agreement or settlement agreements. Same thing, different names to us. And that the employer then offers severance package to the employee as a resolving of any termination or potential termination dispute or in an actual termination dispute.
Yeah, no, that's really interesting. Actually, when you started saying that, I was kind of like, employees must always challenge, if it's on a personal basis, they must always challenge it unless you've got a settlement agreement.
Yes, basically, unless sort of it's a theft or, really clear cases, but in a poor performance case or in those type of more usual circumstances whereby the employee doesn't really have the perfect fit or the best attitude and all of these situations, it ends up with a termination agreement, definitely.
Yeah, that's really interesting. Well, thank you, Åsa. That's been great. And please join us in the next podcast where we'll be covering other key employment law topics in Sweden.